nervous shock. This branch of law of tort is of the recent origin. This is testified by the fact as far as 1888, the Privy Council in Victorian Railway Commissioners v. Coultas did not recognize injury caused by a shock sustained through the medium of eye or ear without direct contact. This view was, however, rejected and an action for nervous shock was recognized, but with the limitation that the shock must arise from a reasonable fear of immediate personal injury to oneself. As in Burhill v. Young, Lord Macmillan observed in this regard, "The crude view that the law should take cognizance only of physical injury resulting from actual impact has been discarded, and it is now well recognized that an action will lie for injury by shock sustained through the medium of the eye or ear without direct contact." Under the cases of nervous shock, the plaintiff has to prove the following things. 1. Necessary chain of causation between nervous shock and the death or injury of one or more parties caused by the defendant's wrongful act. 2. Plaintiff is required to prove shock caused to him by seeing or hearing something. Physical injury is not necessary. 3. Close relationship of love and affection of plaintiff with the primary victim is necessary to be shown, and also that his proximity to the accident was sufficiently close in time and space. However, it has been held that the primary victim need not be a near relative of the plaintiff. Thus, a man who came up on a scene of serious accident for acting as a rescuer when suffered a nervous shock was allowed to claim the damages, Chadwick v. British Transport Corporation. Also, where a crane driver, the plaintiff, suffered a nervous shock when he saw that by the breaking of a rope of crane, its load fell into the hold of a ship where some men were at work, was allowed damages when the rope had broken due to the negligence of the defendants, Dooley v. Camel Laird and Company. Where the plaintiff suffered nervous shock when disaster at a football match was televised live and in news bulletins, but without depicting the suffering or dying of recognizable individuals, were held not entitled to damages, a Luke's case. 4. Damages for nervous shock were not limited to psychiatric damage resulting from witnessing personal injury, but could be recovered where the plaintiff witnessed destruction of his property caused by the defendant's wrongful act, Atia v. British Gas Pick.